ready, but I need another week.
Okay, we're back on the record. Time's yours, Ms. Fine.
Thank you, Your Honor. As I said when I started this morning, and I did an opening statement, I said we need a roadmap. Ms. Johnson has been given numerous roadmaps, and every time she's been given a roadmap, she's delayed it, she's misrepresented it, she's filed complaints, she's filed reports, she's not worked honestly, she's delayed in getting releases, she refuses to follow the direction of the particular expert until finally, 2 years after she was ordered to get psychiatric therapy or psychological therapy from a PhD, she finally does it. And so she finally starts to communicate and answer the questions directly. There is not one email in this from Mr. Horodesky that states that's delayed in any way with respect to the care of this child. There is, and the court ordered specifically that only Dad was to get medical treatment for this child. Dad got medical treatment for the child, and if there was an issue, then Dad should have been advised. So instead, Mom goes ahead and takes care of certain things. The dentist, the warts on his neck, sunburn, all kinds of things that she should be talking to Dad about and co-parenting. She doesn't. The child had an incident, kids get hurt. Dad rushed him to the hospital. We have an email that's been admitted that shows that he contacted her immediately. There was no delay. Mom didn't go to the hospital. I don't know why Mom didn't go to the hospital. No one told her she couldn't. You can look at Margaret Pickard's reports, Exhibit 5, that's dated March 28th, 2014, which has been admitted, Exhibit 6, which is her report of April 28, 2014. And on those reports, both of them, she talks about the recalcitrance of Amber and how Amber is not cooperating and Amber's not co-parenting. We didn't file a motion right away, Judge. We waited. Again, you heard the testimony of Ms. Steinkamp. You heard the testimony all the way around with Mr. Lenkite when I said she was waiting to get joint. Judge Hardcastle awarded Mr. Horodesky primary physical custody because of everything you've heard over and over and over again. And Mr. Horodesky, and then she appealed it, and we went to an appeal.
Your Honor, I'm going to object that this is all pre-McMonagle, and none of it came in testimony.
Closing argument,
Right.
I'll give her some leeway.
Just a little. And then we go to the settlement conference, and we agree to go to joint physical custody if she'll just go to therapy. Getting her to therapy took 2 years, but she went for 2 or 3 times with this other person who we just trusted. I knew nothing about her, but I trusted that she was going to get therapy. She stopped it as soon as she got joint physical custody again. So how many times are we going to let this woman play the game with us? Look, we want nothing more than to co-parent. She's been the one that hasn't co-parented. She's been the one that's been recalcitrant. She's been the one that's filed long oppositions and documents that just ramble on and on and on. You heard from Ms. Steinkamp that she got communications from her that just didn't make sense, that were not logical. She's histrionic. That's what her position was. Her opinion is that she's allowed to have an opinion. She was an expert. Dr. Lenkite's not going to say anything bad, but he talked about how hard it was to redirect her. And I'm afraid that if you were to grant her joint physical custody or more than what she has, I don't have a problem with it going back to the schedule if we can be guaranteed that she's not going to play the same games that she's played with this child since the beginning, which is alienating him, which is not letting him know how important it is to have a relationship with his father's family, and that when he walks by them, the child should have permission. Go hug and kiss your cousins goodbye. Go kiss your dad goodbye. He can't do those things because he's afraid he's going to hurt Mom. Whether or not Mom has said it to him, there's that ego cathexis, or whatever it is that Katie Steinkamp indicated. Mom says she never called Ray her concern over Hayden's bad grades, which aren't bad, after she requested them. I'm wondering, does she really care? And I asked her if she gets alerts, and she said no, but then she testified she does get alerts. So which is it? I can't really follow her. The records to other counselors, she delayed. Mom either directly or indirectly is undermining effective love for both of the parents. In Margaret Pickard's reports, there was a question asked of Dad, why would you pick Givens? Didn't you have joint physical custody? And at that particular time, I believe that that Margaret Pickard had written her report or was preparing a report asking, and I believe it's in the report, and on April 28th, that he be given primary physical custody again because of all of the malfeasance that was going on, for lack of a better term. There's so much that's being said about Givens. Why would you, if it ain't fixed, if it ain't broke, don't fix it. We have a child who's been there for 3.5 years. He's doing well, he's got friends, he's got family. Why would we change it? We'd change it if there was a benefit. There isn't any benefit. We've worked very hard to get him there. When mom wasn't working hard, dad was working hard. We have a beautiful, well-adjusted child now because of dad and because of the consistency in the therapy, which wasn't being done before then. So, Your Honor, I'm merely asking that the best interest of this child be met, that we be able to keep Margaret Pickard. She admitted in her, if you remember her request for admission, everything except that she filed reports and complaints against Ponzo, against me, against Margaret, against Katie Steinkamp. And yet, she told all these people that she had filed complaints with the bar. She even said she filed complaints with the bar.
I'm going to have to object. This is way outside of the scope of testimony.
Okay.
In her request for admission, she admitted everything except for that. Remember, we had a hearing, and you said, Ms.
Yes,
Fine,
so
come back here, and if you can prove
Ms.
it.
Fine, I mean, let's get back to the argument.
I'm just proving that she did file those complaints, so she.
That was not what the testimony showed. That's my objection.
Noted. Continue, Ms. Fine.
In closing, Judge, nothing's changed. Miss Johnson still loves her son very much, that's true, but still believes everybody's undermining her. Everybody's playing games and everybody's railroading her. Until she knows that she's not being railroaded and she's not being undermined, nothing's going to change. Thank you, Your Honor.
Your Honor, what is clear from the testimony from everyone in this matter is that there's significant communication issues that are going around. They're not just from defendant. There was communication issues with plaintiff on stand as well. Defendant is working on her communication issues. You've heard the testimony from Dr. Lenkate that she's learning avenues to express her feelings and her desires more cohesively to all parties involved. And you heard testimony from plaintiff that there has been a change in Amber's behavior since Dr. Lenkite got involved. Conversely, you heard testimony about how plaintiff has used sole legal custody as a mechanism to cut Amber out of decision-making. The enrollment in sports that occur very late, yet there's an objection to late nights on Sunday. The always after the fact emails about medical visits and medical decisions, and the fact that there was no communication whatsoever about a major overdose that had the child in the hospital for hours. Apologize. Conversely, Amber has not been given the opportunity to correct any concerning behaviors that plaintiff or Ms. Pickard have had. You heard testimony from Dr. Lenkite about how the only concern he heard from people was about communication. Had there been any other concerns posed to him, he would have worked on those, but that's not the intention in this. Plaintiff knew the entire time this was going on that my client was going to Dr. Lenkite, yet he failed to inform Ms. Steinkamp about that link between my client and the therapist. And that makes it so Ms. Steinkamp cannot give Dr. Lenkite any concerns whatsoever. That was impossible for him to work on whatever other issues may have existed that plaintiff or that even Margaret saw. You heard testimony from Margaret that my client did get therapy with Katie, and that Margaret's objection to Katie was that she didn't have reports. It's not that Amber wasn't going, it was that Katie wasn't up on the history of this case, and that's nothing that should be held against my client. In short, it's not in the child's best interest to continue with primary physical custody being awarded to plaintiff or sole legal custody to plaintiff. the testimony has supported the fact that plaintiff has used this as a mechanism to justify cutting Amber out of the decisions, things that he was doing well prior to this hearing. And you've also heard testimony about how the child, he has a relationship with mom. Even the parenting coordinator has not suggested that custody remain as it is or be limited even further. And so in short, we would ask that the parties return to a more extensive custody schedule for my client. Thank you. And, sorry, and joint legal.
Huh?
And joint legal. Thank you.
All right,
Two things.
yeah.
I showed the court that she was untruthful on her FDF and on the reason why she left her last employee. Mr. Lenkite didn't reach out to Ms. Steinkamp or to Margaret. He just, it was all self-reporting. He said she had a psychosis. He did report that, and she was paranoid, and that's all. And the releases were delayed. Again, I'm repeating that, but I'm just trying to hurry.
Thank you. I'm going to take the matter under advisement. You'll have a decision within the next 2 weeks.
Thank you, Your Honor.
Thank you, Your Honor.